Majority Floor Leader.
Yes, well, all of the requests are denied, Mr. President, for the record, including the request for the ABS-CBN custodian. So, finally, Mr. President, on March 9, Mr. President, I move to submit the motion.
On our motion for the hearing on our affirmative defenses, Your Honor. We will need to understand, Your Honor, that the same is hereby denied, Your Honor.
Yeah.
We understood in the previous ruling of this Honorable Court earlier made, Your Honor, or promulgated, that what was denied is a preliminary hearing. And this is in conjunction with expediting proceedings, Your Honor. We were then satisfied that the introduction of our evidence, Your Honor, in connection with the affirmative defense, and that we are prepared to do, Your Honor. For witnesses, and also we have not received any final adjudication on affirmative defenses we have set up in our answer, Your Honor. And this more particularly involved the existence, Your Honor, of probable cause and other matters in relation thereto, which nullifies the entirety of the proceedings being held by this Court. We are charged with notice, Your Honor, that there may be some objection to this, because allegedly we have gone this far, but we are entirely hopeless, Your Honor. We have filed a motion for preliminary hearing that was denied, Your Honor. And our understanding of that denial is we are precluded from presenting evidence on the affirmative defenses at that time, Your Honor, but never at any instance before the case submitted for decision. Hence, we proceeded in participating with the trial on the merits, Your Honor. And there are so many instances, Your Honor, even in the ordinary court of justice, Your Honor, where a preliminary hearing on the affirmative defenses or a motion to dismiss or a demurrer to the evidence had been held in abeyance only to be resolved at the time or after the parties had been heard in a trial on the merits. That was our assumption, Your Honor. We have no reason to entertain the belief, Your Honor, much less concur with the present developments that our affirmative defenses had been totally denied, Your Honor.
Your Honor, I hope you understand our position. The rules governing preparation of the complaint on impeachment or resolution on impeachment is a function of the House. This particular impeachment case was filed under paragraph 4 of section 3 of Article 11, and I would like to read to the public and to this court the provision of paragraph 4. In case the verified complaint or resolution of impeachment is filed by at least 1/3 of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith begin. As far as this court understands this provision, there are two parts. That the complaint must be verified. Remember correctly, and I have is this the articles of impeachment? I have here the articles of impeachment. Republic of the Philippines, House of Representatives, House of Representatives Complex, Constitution, Hill, Quezon City, in the matter of the impeachment of Renato C. Corona as Chief Justice of the Supreme Court, Representatives Neil C. Tupas, Jr., Joseph Emilio A. Abaya, Lorenzo R. Tañada III, Reynaldo V. Umali, Arlene J. So there are 5 named congressmen. And as far as we can see, the articles of impeachment filed in this court has been verified. Now, where we have to ask all the members of that court, that the prosecuting body, whether they read these impeachment articles of impeachment or not. That would be tedious, and I think that what was contemplated, as far as the understanding of this court, what was contemplated, that as long as 1, 2, 3, 4, 5, or 100 of those who filed this case verified this complaint, that is the verified complaint spoken of in paragraph 4 of section 3 of article 11. And so therefore, when it reached this court assumed jurisdiction, and in fact we have gone through trial already. The answers and reply to the answers have been filed, and we proceeded to trial. The prosecution closed its presentation of evidence. It's now the turn of the defense to present its evidence, and I think it is the opinion of this court that it's too late to raise the question of verification at this point.
If Your Honor, please, may we be allowed to say something on this particular issue, Your Honor.
Yeah, proceed.
The records will show, Your Honor, that right after we have filed our answer to the impeachment complaint, Your Honor, we have also availed of the remedy of filing a motion for a preliminary on our appeal. The point laid down in the case of Francisco et al. Versus House of Representatives, where it is stated that if there is a defect casting doubt or legality or violative of the Constitution on the part of the impeachment complaint, the same may be raised in the House of Representatives and also in the Senate prior or during the trial of the case. And if the Senate rules either way, then the remedy is there was an adjudication to the effect that raising the issue of non-existence of probable cause goes into the very merits of the case, Your Honor. And as held by the Supreme Court in that case, Justice Panganiban speaking for the court, it stated that during the oral argument, may I be allowed to read for the record, Your Honor?
Yes.
Yeah, right. Senator Salonga and Petitioner Francisco Chavez denounced the second impeachment complaint as violative of due process. They argued that by virtue merely of endorsement of more than one-third of the members of the House of Representatives, the Chief Justice was immediately impeached without upon Justice Panganiban, who was then the due process clause enshrined in our fundamental law, is a condition sine qua non that cannot be ignored in any proceeding.
Just a minute. The proceedings of which body, the House or this court?
Proceedings before the impeached public official in the same issue before this Honorable Impeachment Court, Your Honor.
Well, this is a variant of opinion between the defense counsel and this court, because then if you insist that we will make a finding of as being a probable cause in the articles of impeachment submitted to this court, then we will make a ruling to that effect.
It's not that a ruling, Your Honor, on the existence or non-existence of probable cause is being asked by this representation, Your Honor, but it is a matter of fact that there was no determination of probable cause. In other words, there were no evidences, there were no allegations, because due process requires notice and hearing. And it applies in all cases, notwithstanding the fact that this is proceeding, even though not expressly stated therein. Hence, the House rules on impeachment, insofar as they do not provide the charged official with notice and opportunity to be heard prior to being impeached, are also unconstitutional. We are predicating our action on this particular provision, particular statement of the Supreme Court complaint of the congressman, the chief, whom the complaint against whom the members of the House of Representatives. and the Supreme Father stated, no rule is better established.